Hey, Dan Galligan with Meyer Galligan Law. This is a continuation of the Working with Startups video series that I'm doing. In that last video, I ran through some agreements that startup companies should consider when they're starting their businesses, and realizing that we're throwing out a lot of jargon. I'm in the business of helping startups. You're in the business of being an entrepreneur and running your company, understanding that you may not fully understand what all of those terms were and all of that jargon really means. So I want to break it down to the basics, to the blocking and tackling. And let's start with the buy-sell agreement. You hear buy-sell agreement thrown around. A lot of people, a lot of entrepreneurs may not really understand what that means. And quite simply, and I'll just spend a couple minutes on it, but quite simply, it means if you have a business that's owned by more than one person, so you have multiple owners, and the buy-sell terms cover what happens to stock. Is it restricted or interest? It can be in an LLC. So it's not only stock, but it can be LLC interest. But are those interests restricted from transfer? Generally, yes. But what happens upon the death, disability, termination of employment, or just partners aren't getting along? What do we do? So on death and disability, oftentimes you have a mandatory repurchase, but that's not always the case. I mean, there are just a myriad of options you can go with. There's no right answer. It's just a right answer for your business. But generally, a general restriction on transfers. So someone can't just transfer their stock to a third party without the approval of the other members. So typically what you'd have is if you want to sell your stock and you own a minority, you have to get, that stock is subject to a right of first refusal in the other owners, maybe a right of second refusal in the company. So it's giving the other owners the opportunity to purchase that stock. Adding to that, if you're trying to sell a majority of the stock, you may have majority bring-along rights or minority tag-along rights, meaning if I own a majority of the interest and I want to sell, I can force the minority owners to also sell on the same price and terms. Or if the majority is trying to sell, the minority can say, okay, majority, if you're trying to sell, I get to sell on those same terms and conditions. Generally, you'll have a section on permitted transfers to allow for estate planning transfers. I own stock in a company, but I want to transfer it to the trust for the benefit of my, estate planning purposes. So generally, you'll have a carve out for that with certain circumstances. Then you get to the death, disability. What happens if someone dies? Are you going to have a mandatory purchase obligation where the company or the other members have to buy them out? And are you going to fund that by maintaining life insurance policies or some liquidity to fund that buyout? Or do you just fund it with company proceeds, or company net cash, and pay it on a promissory note? All things that we'll be discussing if you choose to do a buy-sell agreement. Also, you get to termination of employment provisions, and that can go many different ways. You have the termination due to retirement. You have termination due to I just quit. You have termination due to just not working out. We're terminating you without cause. You have the cause termination. You did something bad. You did something really bad to the company. Committed some crime of moral turpitude, whatever other kind of terrible thing you can think of. What happens with your interest? Does the company have the right to buy you out? Do you have the right as the exiting owner to force the company and the other owners to buy you out? And then getting to at what price and at what terms. That's the key. Also, a buy-sell agreement is a great place to put a non-competition, non-solicitation covenant and a covenant not to steal confidential information, to retain confidential information for the benefit of the company, and not let that leak out. Also, to add a provision on ownership of intellectual property, inventions, patents, trademarks, that type of thing you develop as an owner of the company should be owned by the company, and we'll put that into a buy-sell agreement, if you so desire. So those are the basics of a buy-sell. A lot to discuss there. Kind of what I typically do is set up kind of a decision matrix for you to say, okay, in this situation, death, what should happen? This situation, disability, what should happen? Again, there's no right answer. There's recommended ways to do this. There's things that may, what we're trying to do is tailor it for your business and your ownership group. The other thing to consider is in a limited liability company, an LLC, typically you have one agreement which functionally serves as bylaws and a buy-sell agreement all in one, wrapped up into an LLC operating agreement. Whereas in a corporation, you have articles and bylaws separate, and then you have a separate shareholder agreement or buy-sell agreement. So, like I said in the prior video, like I explained, when you're starting up the business, get you formed, and also determine if you have multiple owners, do we do a buy-sell agreement on the front end? What I have done in a number of situations is where you have brand new startup company, limited funds, also kind of they want to make sure proof of concept that the business is actually going to work before they pour a bunch of money into the legal aspects of it. And we certainly understand that. Obviously, we'd like you to spend more on the front end, but we certainly understand that you're trying to preserve cash to run a business. And in that situation, a lot of times what we'll do is we'll have a short form agreement, a memorandum of organization that covers the basics on the governance of in that case, a limited liability company, and have a section that just says the parties intend this to be a temporary agreement and will work in good faith towards adopting a longer form operating agreement with buy-sell terms once the timing is right and you've proven proof of concept and the business is going to work and be profitable. So that is a real quick explanation of a buy-sell agreement. Again, I'd love to have you in and we can talk about how a buy-sell would work for your company and your ownership group. I think I'm going to do a series of these on these basic agreements that we would like to get in place with startup companies. I call it my toolbox of models. So you have the formation document, however you're forming your LLC or your corporation with articles and bylaws or a basic operating agreement, and then this buy-sell agreement. And next we'll talk about, I'll talk about some non-disclosure agreements, employment agreements, independent contractor agreements, things like that. So thank you. Again, we would love to work with you. We love working with startup companies and entrepreneurs. Thank you.